Hello, welcome to our next case, Tinker v. Des Moines Independent Community School District. Another First Amendment issue. We're dealing with the right to free speech and whether and when the government, in this case acting through a public school district, can infringe or otherwise limit a student's ability to express themselves, right? To be able to communicate certain messaging that may be considered offensive or that may be considered controversial. So we'll jump into it. As always, it's helpful to have our First Amendment handy. I imagine at this point that you have the First Amendment memorized. Usually good practice to have certain tried and true amendments and points of law, terms of art memorized and know their history and know how they're appropriately used. But anyway, we'll dive into that, get into the facts of this case. And again, we're situated in the 1960s. So 1960s, again, like we've talked about, a lot going on, right? A lot going on. I'm not sure as far as what sort of historical analysis that you have done for the 1960s, but there is a lot to unpack. And if you know anything or if you have any sort of fascination, this is where a lot of our current issues probably can be traced back to. We can look at sort of the social and cultural and all sorts of other threads going through our society. But the Vietnam War is a huge component of the 1960s. So Vietnam War is going on. We don't really need to get into it other than there's basically a two-sided debate going on in the United States. One side is patriotism. It's the sort of legacy war, right? You were the United States and we're fighting a war for perhaps just reasons or good causes. And we're sending our troops and supplies and weapons and all sorts of things to Vietnam to help with their liberation, depending on how you look at this, try to stop the spread of communism or other sort of malfeasance that is going on within the country. And so we're supporting a certain side. And again, depending on how you look at it, this is a good thing. Let's just couch it in good. So Vietnam War is going on, patriotism, right? We're supporting anything the United States is doing within their war effort. It should start sound like the Schenck case of the United States. And so that's one side. The other side is looking at this, and there is film going on. There's real-time journalism taking place, and there's a lot of questions that get brought up, whether this is a good war or we should be there in the first place, or what our troops are doing are actually furthering any sort of cause of democracy or justice, especially with regards to the local population there in Vietnam, how certain methods of war and order are being established within the country. So all to say, that's sort of setting the stage. That's going on. And then we have the Tinker family. Tinker family, I believe, is pictured here. Very convenient photo, thanks to maybe Wikipedia or Google or, I don't know, somewhere on the internet. These black armbands, right? We read the case already. These are the black armbands. So I think that's also important just to sort of have a visual of what we're talking about here. So facts of the case now, we're dealing with, I think, about 4 or 5 maybe students that got together with their families to decide to wear these black armbands to protest the Vietnam War. They're school-age kids. I think the range was from maybe 8 to 17 or 16. We're talking school-age kids, right? They decided to wear these black armbands for a certain period of time to protest the Vietnam War. It's all good and well, except, again, we're set in the stage of a sort of divisive dichotomy of either the Vietnam War is good, see patriotism, see my country, tis of thee, or bad because the United States is perpetuating violence and destruction and death upon local populations within Vietnam. So, and thus sort of begging the question of what is the United States doing there? What sort of mission is being accomplished? So, all to say, 1960s, a lot of protests are going on. A lot of cultural influences are taking place and shifting around sort of the norms that our country had been used to assuming, really, or experiencing at the very least. And so this family, I think it was a couple of families, but anyway, decided to wear these armbands. The students decided to wear these armbands to their public school to protest the Vietnam War. Now, it's important to point out that these are in fact the armbands, and there wasn't any sort of demonstration, perhaps. There wasn't any sort of recklessness, or there wasn't any sort of destructive or causing, they weren't trying to cause any sort of scene. I'm trying to think of a better way to say that exactly, but the oral arguments I had you listen to, that was also a crucial point to be made. These students are simply wearing the armbands, entering the classroom, and proceeding with their day. They're not trying to disrupt the class. They're not trying to interfere with the class. They're not, in other words, they're not like sitting in the class planning, okay, when the third period starts, we're all going to jump up and throw our papers and throw our books and yell, stop the war, stop the war. Nothing like that. They're just truly wearing these armbands to protest the war, protest the Vietnam War. So what happens? The school district gets wind of this before they actually wear the armbands and decide to make a rule to say, if you wear these armbands, then we're going to suspend you. It's kind of what it comes down to. So it's almost like a dress code of sorts, but they particularly point out these black armbands to say, look, if you wear them, you're going to be suspended. It's almost in the same light of you have to have a certain hair length, or you have to shave, or your skirts have to be a certain length, your collar has to be a certain way, whatever it may be. It's just, okay, we're going to make this a rule across the board within our school district to say no black armbands. Inevitably, what happens, right, we have to have conflict. The students still decide to wear the black armbands in protest of the Vietnam War, and they're suspended. They're suspended for a set period of time, and the students, through their parents, basically challenge this and say, wait a second, First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for redress of grievances. So the free speech clause there in the First Amendment, abridging the free speech. So what does that mean, right? We're going to start unpacking that, but that's their basic claim right now. Students come to school wearing the black armbands in protest of the Vietnam War. Okay. The school district has a rule to say no black armbands. Can't do it. Students break that rule, and so then they are suspended, right? Action, consequence. And the students challenge that rule, or their suspension, really, the consequence of it, as a violation of their free speech. Again, Congress shall make no law abridging the freedom of speech. Congress, as we've sort of talked about before, Bill of Rights, First Amendment, generally only apply to the federal government. Through a variety of cases, the Bill of Rights, and so then, of course, in this case, the First Amendment can apply to the states through the 14th Amendment. What that then means is the state, acting through this public school district, cannot abridge the students' freedom of speech. That's their claim. That's the petitioner's claim here, the tinker's claim, to say this rule that was promulgated by the school district, the public school district, the state, abridged our freedom of speech. And because it violated our freedom of speech, violates the Constitution, see Marbury v. Madison, and as a result, it should be struck down. So that's That's where we're situated. They wear their black armbands. They don't necessarily have to say anything. That's an important point. But nevertheless, it communicates a certain message, and whether the school district could restrict that message is the issue of the case that we're going to dive into more. So, court makes a pretty good observation, pretty good quote here. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. That's sort of operating in the background of this case. You have students, again, I should know this, but 8 to 16, thereabouts, is the age, and they're going to school, and there's sort of a operational principle here that students basically need to get in line. They basically need to be able to follow the rules, the dress code, right, the policies, any kind of rules that they would have to abide by to participate in extracurricular activities. All sorts of rules and procedures are in place to govern students' behavior and their actions. So in other words, it's not like they're fully grown adults that are in the quote-unquote real world outside of the school and now participating in a protest or wearing a shirt or working, right? If you're at your job site, your employer can dictate all sorts of things that don't necessarily violate First Amendment rights because it's not the government. It's not the government acting through, in this case, the public school district. So with that operational principle, it almost has to be asserted or concluded, at least, start with this thought of, now wait a second, nowhere in here are we limiting who the Constitution applies to. We just know that it generally deals with persons. And so if we know that the government cannot make any law that abridges the freedom of speech, then it's sort of a foundational principle here that would pertain to students, right? Non-adults, right? Minors, students in the public school. So, in other words, they still have the freedom of speech and assembly, press, like all sorts of other rights that are granted through the Bill of Rights. And so it's just important for the court really to establish that principle. It's, again, the kind of operational mode. We're in the 60s. We have a pretty tried and true, pretty general claim, but I'm okay with it. Excuse me. Authoritative structure, a hierarchy here of how school districts are going to function and how they're going to manage children through their young adulthood as they then graduate from high school and pursue jobs or college or whatever else it may be. So we get to the issue of the case, whether prohibiting the armbands in public schools as a form of symbolic protest violates the students' freedom of speech protections. So again, we know that students weren't saying anything, right? They weren't saying, I disagree with the Vietnam War. Probably wouldn't even be a case, probably wouldn't even be a lawsuit, unless, again, the school district came back and said, nope, can't say that. Then that would be a really interesting question. But we're couched sort of, again, in this time period of our country's history where this very controversial war is taking place. Very simplistic take, but two sides of either, yep, what we're doing is good because the United States can't make a mistake. It is exercising its good authority to help out certain populations within Vietnam to establish democracy, to fight off communism. And the other side of it would be, nope, we are killing civilians, we are wasting resources, we are destroying the countryside, like whatever else may be. It's just bad. It's good and bad. So to have this take with regard to wearing armbands now takes sort of a next step here. Again, if it was a verbal statement, and then the school district came back and said, nope, you cannot say I disagree with the Vietnam War, almost be an easier case here. But now we're looking at a symbol. We're looking at these armbands, black armbands with a peace sign on it, where that symbol was given the meaning of I disagree or I'm protesting the Vietnam War, or at least I'm drawing attention to the Vietnam War and the casualties taking place there, and perhaps the unjust casualties as to why these people, Americans and people of Vietnam, why are they dying? At what point in time do we stop and just question that? So whatever may be, that was at least the symbolic representation of these armbands. And so for the school district to essentially know that's what the symbol was, or what these armbands represented, and then ultimately say, cannot wear these armbands, was essentially the same as saying you can't disagree with the Vietnam War. You cannot protest the Vietnam War. And they're going to come out with a policy basically to establish that. So court gets into it. Court looks at it and says, no, armbands are representing speech, and that is entirely separate from the actions or conduct of the students participating in it. So it's not a matter of who or what they're doing. It's it's just the symbol. It's just the armband. Let me go back. Let me park on the picture of the armbands. So it's not that it's the tinkers that are saying one thing or another. It's quite literally these armbands are promoting a certain symbol, a certain speech. And by virtue of limiting or prohibiting or abridging that free speech, the school district is ultimately violating the First Amendment rights that the students have to wear these armbands. As we already pointed out, the court acknowledges that they do not lose their First Amendment rights when they step onto the school property. That's really important. Again, it's sort of an operational principle that students basically just get in line. Here's the school rules. You're going to follow it. There's no challenging it. There's no thinking through, wait a second, I'm entitled to whatever, X, Y, and Z. Court has to basically step in and say, no, these are still people. They are still afforded rights given by the First Amendment in this case. And then the court also gets into this test that we'll see here in a second as to what kind of speech would violate the First Amendment, or would not be protected, I should say, would not be protected by the First Amendment. So the substantial disruption test. Let me get over to the case real quick. Okay. So we're here in the case. In order for the state, in the person of the school officials, so again, we're Congress, and this is what it says literally in the First Amendment. We know through a variety of other cases that the First Amendment, as well as the other Bill of Rights, can apply to the states through the 14th Amendment. And then from the state level to the school level, those are school officials. They're basically acting on behalf of the government, or the state, of course, in this case. In order for the state and the person of school officials to justify a prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. Certainly, where there is no finding and no showing that engaging in the forbidden conduct would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school, the prohibition cannot be sustained. So I think the court points out earlier too that maybe it was later on, the school was basically trying to get ahead of really any kind of controversy here. They didn't want that sort of tension, again, that was happening at the national level, to be brought into the classroom and really disrupt the class proceedings. It's easy to imagine, I guess, if let's say the school was just divided for simplicity's sake, and we knew the school officials would know basically that half of the school population would think that this was a good war or just war or whatever, and the other half would think that this was a terrible war and was a atrocity on several levels. If the school officials knew that and they were trying to navigate that sort of tension, then it would sort of make sense to say, you know what, we're just not going to do it. Don't wear those black armbands because we know it would incite chaos and it would disrupt the school day and it would distract students from learning, which is the whole point of being in school. So rather than get into that sort of murky water and having sort of those tensions and those distractions, rather than kind of bring that chaos or the controversy into the classroom, the school just gets ahead of it and says, you know what, no, we're not going to do that. You're not going to wear these black armbands. But the court points that out. The court says, hey, wait a second, guys. We can't just have this desire to avoid the discomfort and unpleasantness that comes from unpopular opinions. That's not enough to limit someone's free speech or right to proclaim certain messaging. That's not going to cut it. What will be enough to say, nope, there's no First Amendment rights, is if there is a material and substantial interference with the operation of the school. So if we know some sort of speech, whatever that could be qualified as or defined as, will materially and substantially interfere with the school's operation, namely educating children or proceeding with lessons or whatever else it may be, then we'll say that's not protected by First Amendment protection. So we call this the substantial disruption test in law. It's amazing how these things come to be, but basically the Tinker decision is handed down, and so now schools and other actors across the board have to start questioning, okay, at what point in time can we limit a student's speech? So, in other words, let me take a step back real quick into a caveat. School assemblies. This was another case, but I'll just kind of speak in general terms rather than particular. When you have school assemblies, it's good policy to not have students be able to say whatever they want to. If they had free reign at the microphone in front of their peers, and let's say it's like a community event and there's teachers and community leaders and parents and family members, you probably don't want that student to get up there and start espousing and pontificating about any given matter using any kind of language. There should be parameters in place that would limit or otherwise discourage through punitive means a student's verbal communication from getting into perhaps threats of violence or encouraging drug use or being overtly sexual in nature. We probably don't want that student to say those things, even if it's, quote unquote, abridging that student's freedom of speech. There's a give and take, in other words. We saw that in the Shank case. If it creates the clear and present danger, which of course, fast forwarding through the case law, but just for our example here, that's when that speech is not protected. And so we'd say the same thing in the public school setting. If there is an opportunity for a student to, again, using this example, speak at an assembly in front of all of his peers and the teachers, principal, administrators, community members, etc., we probably don't want to just say, oh, if that guy's going to get up there and, be extremely crude and vulgar and use obscene and foul language, we probably do not want that to take place. And so there's certain parameters, in other words, that will guard a school's right or ability to limit students' speech. So in other words, if we're looking at this as a spectrum, we can't just say speech is going to cause us to be uncomfortable, and so the school can silence that opinion. Vietnam War, it's controversial. We can't just say, look, just because it's controversial doesn't mean you're going to say you can't talk about it, or you can't proclaim a given messaging like, I disagree with the Vietnam War. On the other hand, or on the other side of the spectrum, we're not just going to allow anything to be said by the student in the public school, because there are other considerations, namely like the functioning or functionality of the school. We have to consider other students there as well, and how their objectives may be interfered with by virtue of obscene or foul or material and substantial interference. So that's sort of the test now that we're operating under. We know on one hand, we don't just want to limit anything and everything just because it could be controversial. But on the other hand, we don't want students to just have free reign to say whatever they want to, because that's also bad. It's also not the objective or the outcome that we want to achieve by virtue of regulating speech within the public school setting. So we call it the substantial disruption test. And the question is basically whether the speech or expression of the student materially and substantially interfered with the requirements of appropriate discipline and the operation of the school. Or might it reasonably have led school authorities to forecast substantial disruption of or material interference with school activities? So, if we can look into the future and see that this expression, this speech, will cause this material and substantial interference, then absolutely, there's no First Amendment right to have that sort of speech. There's no protections in place. So the school, by all means, can go and regulate or limit or abridge that sort of speech. Hopefully that sounds familiar, right? Hopefully that gets to the clear and present danger, the imminent harm, the imminent threat test that we looked at before in our other First Amendment cases. But here we're looking at the school context in particular. Again, with the sort of operational presumption that students go to school to follow the rules, to get in line, to be under or within the bureaucracy and within the hierarchy. And all to say that's how a school functions. These are still minors in the eyes of the law. There are certain protections, sure, but for most part, we want the students to basically submit to this authority and be able to function within the school accordingly. But as the court pointed out, that doesn't mean they forsake their First Amendment rights at the door. So we're going to have a little bit more parameters here as far as what sort of rights are afforded and to the extent of those rights. But that's not to say that they have free reign and they can just say whatever they want to at any given point in time and disrupt and interfere with the objectives and the school activities. Okay, so that's all good and well. Glad the case is out. What does that mean, though? Right? What sort of effect has that had? Well, there's a lot of cases that have been questioned or that have been brought up in light of the Tinker decision. And so this will be one of your first opportunities to start preparing really for what the nature of the final will be by getting this hypothetical that we're about to talk about and thinking about it in light of the Tinker case, but more importantly, being able to read a fairly recent Supreme Court decision on your own and decide ultimately where that line can be drawn in light, again, of this substantial disruption test, as well as this other case that I'll have you read. So let's get on to that hypothetical. So let's imagine that there is a debate team at the school. Let's just say it's a public school. We know it's a state actor. In other words, it doesn't really matter to get into the details of the nature of the school. We just know it's a state actor. So there's a debate team and there are tryouts for the debate team. I'm not sure if we ever had tryouts, come to think of it, but let's say it's just a widely popular extracurricular activity And the student tries out for the debate team and is ultimately denied a position on the varsity debate team. So there's, top line varsity, and then there's a junior varsity team that goes to some tournaments but not all, and then are put in different bracketing because of that difference in skill. So this student is preparing perhaps, and has done a lot of the practice and argumentation and research, and he thinks that he deserves a spot on the varsity debate team. He tries out, he does not make it, and he is basically said, hey, keep practicing on a junior varsity team. We'll see you next year. We'll see what happens next year. He's angry, he's mad, he's upset, he's frustrated, and he goes home. He's no longer at school, and he gets out his phone and goes to a social media account of his choice. And let's just suppose further for the hypothetical, it's his, it's not an anonymous account, and he is friends with or connected with, or other people, other students know it's his account, have seen him post on that account and follow him, or shows that I'm out of touch. Our friends, like if it's Facebook, I guess, or follow, I think Instagram does that. So anyway, that's sort of part of it. And he posts pretty bad messaging with regards to calling out the school and calling out the debate coach and calling out the people that did make the varsity team, saying that they are terrible and that they should not deserve it, and calls the school terrible names and calls the coach terrible names, and posts it and shares it out and blasts it on the interwebs. Next day, or I guess really that night, his peers, his colleagues, his other, I guess, debate team members or students in his class, whatever it may be, see that, and they talk about it, and then they ultimately get it back to the debate coach and the principal of that school. That school looks at the messaging and looks at what was said about the school, about the debate coach, about the other varsity, or I guess the students that made the varsity team, and decide to suspend this person, this student, based on a law or a policy or a rule that the school has about obscene messaging. Basically says cannot use foul language and obscene messaging on school property or on any social media sites. That's sort of the general rule. So then the question is presented as to whether this student's First Amendment rights were infringed upon or abridged, violated in any way by virtue of this school's rule against obscene messaging. Okay, so that's sort of the hypothetical. That's a question presented. What do you do with this, in other words? So if we can parse it out a little bit more and just think about it, he's not on school grounds. He doesn't say anything on school grounds. He is home. He is away from the school, right? But what he says is very disruptive. It causes a stir. His colleagues, his classmates are talking about this. The people that were called out feel really bad, and they feel threatened perhaps, so they feel discouraged at the very least by what he said and what kind of names he called them. The debate coach, same thing, as a representative of the school, was called out as well. The school itself was called out. The program was called out. But he was at home, and it was his own social media accounts, and it was his own posting, and it had no way to do with the school. He had the ability to say what he wanted to on his own social media accounts. Again, not on school time, not on school property, not on school Wi-Fi, completely separate. But this is sort of the consequence it has. So can the school suspend him, in other words? Can they, in fact, say, hey, we have this policy on the books about obscene messaging? Can the school enforce that rule? Or does that rule violate this student's First Amendment protections? So in other words, can this student in fact say what he wants to, or does it cause a substantial interference with the ongoing activities of the debate team or the school for that matter? That's the question. That's the question presented. Like I said, we read the Tinker opinion. That will be very helpful to start formulating your arguments and put together a opinion and put together perhaps a counter opinion as well, or a dissenting opinion if you have a dissent you'd like to put in. Basically, we're going to cover, and I'll have more instructions on this, but we're going to take this example, this hypothetical, and wrestle with it in light of the precedent set forth in Tinker. But what I also want you to do with this assignment is to read this case, the Mahaney v. BL case, to reconcile this issue. This issue was brought to the Supreme Court, and I want you to basically work with the existing precedent. It comes from Tinker. Figure out how to work with these facts, and then read this new case, the Mahanoy case, in light of this hypothetical, and see how the Supreme Court addresses this issue as well. So I think it'll give you a really good opportunity to wrestle with existing case law that came out of the 60s, but also wrestle with very recent case law on a very real topic, right? Social media didn't exist in the 1960s. So hopefully you find that pertinent, but I really want you to reconcile and work with and dive into these competing issues as to whether and to what extent this student has First Amendment rights and how they can be protected based on existing case law. So I'm sure there'll be questions. Like I said, I'll put this in more structure. I'll provide this typed out or provide the questions, whatever else may be helpful for you all. If any questions, as always, please let me know. This is giving you hopefully a decent amount of time to start wrestling with this, start to work with this concept, start reading this other case as well. And so like always, please email me questions. I'm happy to talk things over, happy to discuss things. I want to make sure that you have the opportunity to start thinking like an attorney, start using that grammar and the logic, the rhetoric that you already have, and start applying this legal precedent and legal reasoning to this hypothetical situation. Okay, till next time, have a blessed week. Thank you very much for your time, and I will see you then.